Does the Fourth Amendment protection against unreasonable searches and seizures require the police to obtain a search warrant before wiretapping the outside of a public phone booth? To find out, you have to read Katz versus United States. But it's 60 pages. Don't have time for that? I've got you covered. Stay tuned as we dive into this landmark case. This is TLDR, where I cover New York Court of Appeals cases in 5 minutes or less, but this is part of a special series I'm doing on landmark cases in the U.S. Supreme Court. Today we're diving into the pivotal case of Katz v. United States, cited as 389 U.S. 347, and published on December 18, 1967. The core issue? The very meaning of the Fourth Amendment's protection against unreasonable searches and seizures. Before we delve into the specifics of Katz v. United States, it's important to understand the Fourth Amendment. The Fourth Amendment is a part of the Bill of Rights, the first 10 amendments to the U.S. Constitution. It was ratified way back in 1791. This amendment guards against unreasonable searches and seizures, requiring any search warrant to be judicially sanctioned and supported by probable cause. The Fourth Amendment is centered on the concept of privacy. But the language of the amendment is not clear. Does it apply only to things? Does it protect people? Does it protect places? What are the guiding principles that define the contours of the Fourth Amendment? It's cases like Katz v. United States that help define these terms in the context of evolving technology. So, what are the facts of Katz v. United States? At the heart of this case is Charles Katz. Mr. Katz regularly placed illegal gambling bets from a public telephone booth. Unbeknownst to Katz, the Federal Bureau of Investigation had been surveilling him, suspicious of his activities. The FBI knew Katz used a particular phone booth when he made the illegal bets, and they wanted to gather evidence and recording of him doing so. In an attempt to gather evidence, the FBI attached an electronic eavesdropping device to the outside of the phone booth. That's an important detail. They never entered the phone booth itself, but by attaching the listening device to the outside of the phone booth, they were still able to capture Katz's incriminating conversations, which were later used to convict him of transmitting wagering information across state lines. This seemingly straightforward surveillance operation sparked a legal debate over whether the FBI had violated Katz's Fourth Amendment rights. The journey of Katz v. United States through the courts is a story in itself. Initiated in a California district court, Charles Katz was convicted on an 8-count indictment for transmitting wagering information by telephone across state lines, violating federal law. The evidence leading to his conviction was partly based on the FBI's recordings from a public telephone booth, which Katz frequently used. Unsatisfied with the ruling, Katz appealed to the Ninth Circuit Court of Appeals. He contended that the FBI's actions invaded his right to privacy, thus breaching the Fourth Amendment. However, the Ninth Circuit upheld the district court's decision, echoing their sentiments. Refusing to back down, Katz petitioned the Supreme Court. Acknowledging the significance of the constitutional question at hand, the Supreme Court granted a writ of certiorari, agreeing to review the case. This decision was prompted by the need to clarify the scope of the Fourth Amendment in the context of modern technology. With that, the stage was set for a landmark Supreme Court decision. The Supreme Court's decision in Katz v. United States was groundbreaking and very revolutionary. The court held that the Fourth Amendment's protection against unreasonable searches and seizures applied to Katz's conversation in the phone booth, even though the police never entered the booth itself. The reason why? Because Katz had a reasonable expectation of privacy in the phone booth. The Katz case formalized the two-part test on reasonable expectation of privacy. 1. The defendant exhibit an actual subjective expectation of privacy, and 2. That the expectation is one which society is prepared to recognize as reasonable. If both of those parts are satisfied, then law enforcement is required to get a search warrant before violating that privacy right. The consequences of this new holding cannot be overstated. The court held that what a person seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Justice Harlan, in his concurring opinion, introduced the idea of a reasonable expectation of privacy that has since become a cornerstone of Fourth Amendment jurisprudence. However, Justice Black notably dissented, arguing that the Fourth Amendment protects things, not places, and thus, the government's action on the outside of a phone book did not constitute a search. This decision had far-reaching impacts that are still felt today. Katz v. United States fundamentally shifted Fourth Amendment jurisprudence, propelling it into the modern age. No longer confined to physical spaces, The protection of privacy now extends to our conversations, our electronic data, and beyond. This case has influenced countless subsequent cases, shaping the way our legal system perceives privacy in the digital age. It's a testament to its enduring significance. And that, in a nutshell, is the landmark case of Katz v. United States.
If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.